Welcome to the Catholic Charities Immigration Legal Webinar entitled Humanitarian Parole Program for Cuban, Haitians, Nicaraguans, and Venezuelans. My name is Zer Vang. I'm the legal director of the Immigration Legal Services Program with Catholic Charities of the Archdiocese of Dubuque. And today we've got Rye Meyer, one of our immigration attorney with Catholic Charities, that will be presenting today on this topic. And we hope to have time at the end. Well, I know we will have time at the end to answer and discuss any questions that you will have typed in there. We'll make sure to reserve plenty of time for that as well. So thank you again. And so Rye, if you want to take it away, I'll turn it over to you.
Thank you. As Zer said, my name is Rye Meyer. I'm one of the attorneys on the Catholic Charities Immigration Legal Services team. And I'm really happy to be here today, happy that we could bring this information to all of you. And I'm really happy that you're all here too. We're just at Catholic Charities, we're very happy to offer this program, and we couldn't do it without people supporting our program, showing interest in our program, donating to our program, but most of all, being concerned for and caring about our immigrant population, the population who we serve. One of the main questions that I oftentimes get, regardless of the type of presentation, is people know somebody who may have an immigration question and they want to bring that up to see what an attorney says about it. Something that I'm not going to do with this presentation is give any sort of third-party legal advice for somebody that I don't know. But that's okay, because the people that you know who might have an immigration question are welcome to call us and set up a free consultation so they can find out what their options are with their specific situation. The contact information is there on the slide. And today's presentation, we're just focusing on humanitarian parole, specifically for Cubans, Haitians, Nicaraguans, and Venezuelans. We're going to give a lot of information on these slides. I'm sure you'll all be very thankful to know that I'm not a believer in reading off the slide word for word, but there is a lot of good information on there about who can do what within this program and how. And as Zer said, we will have this information available either by recording or in some other summary that you can access this later. So don't feel like you have to frantically write down notes, but just understand that I'm going to be summarizing this with a bit more detailed information on the slides. And, save your questions to the end because there's a lot to cover. A lot of it will be contained in the slides. We'll talk about that at the end. Okay, now we can talk about what is parole. So humanitarian parole and the forms that you submit to the United States government, that you submit or that an immigrant who wants to access these programs may need to submit, those things aren't new. They've been part of our immigration structure for a long time. When it says on there INA 2112D5, that's the name of a law that authorizes this. And in the very first bullet there, DHS stands for Department of Homeland Security. That is the federal agency under which USCIS exists, United States Citizenship and Immigration Services. That's the agency that adjudicates this type of request and most immigration requests. It's a federal agency that looks at the law, that looks at the evidence that someone submits to try to access that law and decides whether or not to allow it. The process has been around for a long time. And it's been fairly versatile over the years. As this slide says, there's many different kinds of parole. What's unique about what we're presenting today is the United States government and DHS, USCIS, have created a particular structure to look at these type of applications that are coming for people who are in Cuba, Haiti, Venezuela, or Nicaragua. That's unique, that's helpful. And of course, while I think we all wish that there would be more opportunities for everybody around the globe to access these programs, it is nice for these countries that applicants have a special allocation of federal attention and resources. Let's talk about the background of this program. So this isn't the first time there's been a special program to allow humanitarian parole for applicants from a certain country. We have a series of announcements that the US government has made, usually in response to unrest or a disaster, or in the case of Ukraine, an ongoing war, for some reason, and within a certain time frame, the US government has identified particular programs to assist applicants from certain countries. This is a partial timeline for that. I also want to draw your attention to the limits of this program. So the last bullet there identifies that there are 30,000 applicants processed per month. Zur and I had talked beforehand a little bit about the statistics of how much of that is actually going into play, and I'm not going to get into that today, but the idea is that the United States government is allocating attention and resources to process 30,000 applications for the CHNV face of this program. That's Cubans, Haitians, Nicaraguans, and Venezuelans per month. Whether we actually see that many applications processed or approved within a month, you know, the statistics are still out on that, but that is the goal. And those are some dates of how and when this program came to be. It's primarily done online. For me as a practitioner, I have, my views are sort of evolving on the US government's ability to do things through an online process. In my personal experience, providing services to an immigrant population through Catholic Charities, sometimes the United States government really gets it right. Sometimes you feel like you're just kind of lost in a void, and that USCIS may not really be receiving what you're trying to send them. I would say that for this program so far, the indication appears to be that they are receiving the information you're trying to get them, and it does look like this program is available and working. From my experience as a practitioner, having done one of these for a separate but related parole program, Uniting for Ukraine, it actually worked pretty well. So this is the format that they've provided, and that's the format to which we must avail ourselves. And so far, so good. A little bit more information about on there, particularly the last point about how you actually find out more from the government website and access the interface or portal to actually submit the kind of documentation that we're going to be talking about today. That's a good one to write down, if anything. And we have the overview plotted out on a chart, which thankfully it's a linear chart. Sometimes when I've done presentations or attended presentations related to immigration, the chart's all over the place with arrows, you know, pointing every direction, if this, then that. But this is kind of nice. It's fairly streamlined. Your supporter files online, USCIS reviews, verification of information, travel document ostensibly is issued with that approval that would come from the first steps in this, and then the beneficiary of this program would be able to enter. So this would be a good spot to stop and tell you some of the terms. I sometimes get ahead of myself with acronyms. We already talked about DHS for Department of Homeland Security, USCIS for United States Citizenship and Immigration Services. CBP is Customs and Border Protection. USCIS and Customs and Border Protection are both parts of the Department of Homeland Security. They're both federal agencies that do some kind of immigration adjudication work or decision. Let's talk about who can be a supporter. There are various criteria here. As I said, there's a lot of legal information. There's a lot of definitions. We want to talk about who a supporter is, who a beneficiary is, what kind of bars a beneficiary might experience that would not allow them to access this program, and sort of other people who can access this program through a beneficiary. But these are the legal criteria for who you need to be if you know somebody in Cuba, Haiti, Nicaragua, or Venezuela, and you want to file paperwork on their behalf. So it's pretty broad. It's pretty broad. As the bold copy says at the beginning of the slide, the sort of shorthand answer of who can be a supporter is, if you're residing in the United States and you have lawful residence, if you're here with permission, you probably can be a supporter. If your question is specific to yourself or somebody you know, or you're not really sure, do they fit into one of these categories? I would refer you back to the very first slide that we had about how to contact us for a free consultation to explore specific circumstances in more detail. But as far as generally who can be a supporter and provide documentation that authorizes them to support somebody and bring a beneficiary here from Cuba, Haiti, Nicaragua, or Venezuela, these are the criteria, which then of course leads to the question, who is a beneficiary? Similarly, these are the broad criteria for who a beneficiary can be. As I said, humanitarian parole is a program that has been in US law and addressed by US federal agencies related to immigration for a long period of time. But what's unique about this is the focus on, and the special program for, people from Cuba, Haiti, Nicaragua, and Venezuela. So, much like the criteria to be a supporter, the criteria to be a beneficiary of this is pretty broad. That's nice. We like that when US federal programs are accessible by a broad population of people that might need to leave their country and come to the United States. Are there some barriers? Perhaps. Might be hard for some people to get a passport. Might be hard for some people to provide their own commercial travel to the United States. It's not that barriers don't exist. It's just that, you know, we have to exist within the confines of the program and the law and what it says we need to do. And at least something that we can do from our end, if you're interested in being a supporter or know somebody who is that we can file the I-134A and try to get that approved. So at least USCIS can make the key. And if they make the key, then Customs and Border Protection can open it. So the criteria are pretty broad, but there are some bars. There are some people within these countries that would not be able to access this program. Here they are. So again, I don't like to read specific, just word for word off of a PowerPoint slide. I know you're all capable of doing that yourself. And many of these are somewhat complicated. Bars to entry to the United States. That would be one of those specific questions if you think it might apply to someone who you would like to sponsor. That would probably be another question for a consultation specifically on the circumstances that you believe might apply to the person that you're planning to sponsor to the United States. And as you can see from these bars to eligibility, some of them do make certain sense. The United States doesn't want to admit, say minors when, perhaps their parents haven't approved of them leaving the country or something like that. So just be mindful of what the bars are. And let's talk about immediate family members. So immediate family members, who an immediate family member is, to a certain extent, that's a term of art related to legal processes and how that definition applies to individuals who want to access an immigration process. And here they are. So one of the things for this program that's nice is to be a supporter and to sponsor a beneficiary to come to the United States. You don't have to be an immediate family member. Typically, there are immigration processes for people who are immediate family members to reunite with their family through family-based immigration. But that's not true of this program. As we saw from the earlier slide, just about anyone can sponsor someone with an I-134A for humanitarian parole from one of the listed countries. But immediate family members can also benefit from this. So it's important to have this definition there. And let's talk more about supporters. Again, it's pretty broad. So you can join together with others, and a group can be a supporter. An organization or a business can be a supporter. And you're not limited to just one I-134A for a given beneficiary. And you can kind of swap people out. I always recommend keeping things as simple and straightforward as possible for the US government to allow for easy processing. I don't know if it works or not. Sometimes the US government takes a long time, but being very clear and straightforward about who's who and what the evidence shows can be very helpful. That said, human life, experience, and circumstance sometimes lends itself to complicated situations. So it's nice to see that there's a fairly broad category of who can be a supporter. So we've talked about who can support somebody. A supporter being the person that lives in the United States who wants to ask USCIS to allow someone to come here from Cuba, Haiti, Nicaragua, or Venezuela. That person would be the beneficiary. So what do they actually have to do to ask USCIS to allow entry for that person? Here it is. So the very first one on here, the very first bulleted item, has presented those of us who are attorneys some challenges because this is something that the supporter or the sponsor has to file themselves. An attorney can't just do it completely for you the way we can represent a person in some other forms of immigration benefits. And the beneficiary can't file on their own behalf. That means someone who is living right now in Cuba, Haiti, Nicaragua, or Venezuela cannot ask USCIS to create the key to open the door to the United States. They need someone in the United States to do it for them. And that person who is going to do it for them, while certainly able to consult with an attorney and find out more about this process, at the end of the day, it's going to be their own email account and their own documents that they're using to put in this application. And of course, there's some other criteria there as well. I always try to catch acronyms when I can. So we already know USCIS, that's United States Citizenship and Immigration Services. The I-134A, that's a form. It's a paper form, although I guess in this situation, things are done primarily digitally because the application will be submitted online. But it's a form. It's a form that has certain financial and biographical questions to establish identity and capability of supporting the immigrant who's applying. I-134A is a form. And RFE, which you see in the bottom line there, is a request for evidence. So if USCIS accepts an application on the My USCIS web portal, that's the online interface where you'll be submitting documentation as a supporter on behalf of a beneficiary. If USCIS looks at it and decides they don't have enough to make a decision, they may issue an RFE, or a request for evidence, or they might request biometrics. Biometrics, in short, means that they want to verify your identity through fingerprints, possibly a photograph or other method. So that is the foundation of sort of being started on the I-134A. Let's talk a little bit about completing the I-134A, and I'll let you know, with any government form, there's a lot of paperwork to fill out. There's a lot of questions that it's going to ask to, as I said before, establish financial and biographical facts that show who the sponsor is, who the beneficiary is, whether the person filling out the form has the correct standing to fill out that form and whether they have the financial capability to support the person from Cuba, Haiti, or Nicaragua, or Venezuela who might be coming to the United States. So there's going to be a lot of biographical information. Here's a list to get you started. And on the next slide, we have more criteria. And again, I don't want to read through these item by item. We will have this information generally available later. And if you have specific questions about how or if this applies to you or a particular person in Cuba, Haiti, Nicaragua, or Venezuela who wants to apply, specific questions would be better in the context of a free consultation. But this is the general criteria, what that form I-134A, is going to ask you when you fill it out on behalf of a beneficiary who's currently overseas and may be able to avail themselves of this program. Completing the form is not the only thing that USCIS requires. The form provides them information, but USCIS also wants verification of the information on the form. We call that documentary proof. Another word for it would be evidence. These kind of documents, typically for something where you're going to apply online, you're going to have the original or a good copy of it, scan it, or get it into an electronic format so that these documents about your biographical and financial circumstances can be submitted to USCIS along with your application. And a lot of it's about finances. There is a perception, I don't know if this is true or not, I tend to think that it's not, but at least some of our lawmakers, are very concerned that they don't want to allow people to come to the United States that aren't able to pay for themselves. We know statistically that most immigrants are very much able to pay for their own stay, especially when the law allows them the ability to work here. But the perception is we want to make sure that there's a US person who is able to financially support the applicant from Cuba, Haiti, Nicaragua, or Venezuela. And it does make sense in a way. The idea of humanitarian parole is people from those countries are fleeing some kind of unrest, disturbance, war, or catastrophe. So it is nice to know that the US supporter is able to finance their stay. And it's not just nice to know, it's required. You'll have to provide those documents. And again, they're primarily financial. And once you've provided all that, let's talk about next steps. So, as I said, some results with USCIS programs, at least in my experience, have been mixed when you're doing something strictly online. But that is the interface set up specifically for this program. Early indications seem to be that it is working, at least to a certain extent. And you're going to have to watch your email very closely because that is where instructions are going to appear about what to do next. And something from the previous slides, we don't have to go back, but I primarily focused on the financial documents. There were bullet points in those slides about biographical documents as well. USCIS wants to be confident that the person who's making the request qualifies. As we said much earlier in the presentation, qualifications are pretty broad, but you do have to verify your identity if you're going to apply for benefits for somebody overseas. And of course, that person must provide some biographical documentation as well, and that will be verified again before they're actually allowed to enter the United States. So more next steps, plenty of them. Again, this is part of a verification process to make sure that everybody is who they say they claim to be, and that all of the US government's usual requirements for entry into the United States are satisfied. I'm not going to read each one of these bullet points, but if you have worked through the full I-134A, and if you've already apprised yourself and the beneficiary of the criteria to be eligible for this program, most of these things should already be documented. And if they're not, you'll have to take steps to document them and make sure that this information is part of the record before the person is allowed to enter the United States. When all of this information is in order, then travel to the United States becomes possible. And again, you're going to want to make sure if you are a person filling out the I-134A in the United States, maintain your access to your USCIS account, watch your email very closely in case you receive an RFE, a request for evidence, or in case you get good news that the application's been approved and the person that you are sponsoring is now able to travel to the United States. As we talked about earlier, a passport and paying for the trip falls upon, the beneficiary. I suppose the sponsor could help out with that. And there is a timeline on it. It's not open-ended. You've got 90 days to use the document that USCIS will issue to enter the United States. So, like many things with the United States government, it's hurry up and wait. But if and when you get the approval you've been waiting for the beneficiary to come to the United States, they should be ready to wrap up whatever they need to wrap up in Cuba, Haiti, Nicaragua, or Venezuela and come to the United States. You can request an extension. Sort of as I said before, I like to keep things simple for the United States government. I like to keep things simple and linear, and when they give you an approval, you should act on that as expeditiously as possible. Of course, human life and circumstances sometimes prevent that from happening, so thankfully there is a one-time extension. Delay at your own risk if you have approval for a beneficiary that you're sponsoring to enter the United States. And of course, CBP, as we said before, Customs and Border Protection, USCIS is not going to have an officer at the border waiting for someone to provide the USCIS document. That's going to be Customs and Border Protection. POE stands for point of entry. That's going to be, at the airport or at the port, the point of entry. Of course, the doorkeeper will have the final decision on whether the key fits in the lock, I guess is the analogy that I would use. Parolees can access employment authorization. We put the category up there, C11, and unless you're an attorney, that probably doesn't mean much to you, but there are many different categories of employment authorization in the United States. This is the one that applies to them. And once they get here, that should be something that the person does right away so that they can get that government issued ID, even if it's an elderly person or a minor or something like that. It's still a good idea to apply for work authorization so that you have that document, you have the social security number that likely comes with it, and you at least have that option. That can be a very important tool, even for people who are not planning to work. And of course, for people who are planning to work, this is a required document. That's a huge benefit. Let's talk about other benefits that a parolee is eligible for. So by completing the I-134A and receiving approval for that form and entering the United States with inspection through a Customs and Border Protection review, that person has now entered the United States legally on a process authorized by law, and they are therefore entitled to certain benefits. They've been vetted, they've been allowed into the country, and this is a list of some of the benefits that they can access while their status is valid. But wait, there's more. There's a whole second slide of other benefits that they can access. And I think I speak for all of our team in Catholic Charities when I say it's wonderful that we make this humanitarian process available for people from particularly these 4 countries, but anyone who can avail themselves of this program. They're fleeing oftentimes terrible circumstances, and when they come to the United States, there is a safety net for them because they've accessed this legal program and now can access these benefits. Unfortunately, there's not, right now, a mapped out path beyond the parolee status, which does expire. And I think many of us who are practitioners are hopeful that such a future path does become available, a clear path in the future. There are some paths to permanent residency or other legal immigration benefits that can arise when people enter illegally. They're here in status, and circumstances may change in their lives to make other programs available. But that's not a given. That's not an automatic step. And perhaps it should be. But I know that's going to be a question that many of you have. Okay, a supporter has appeared and is qualified, filled out the I-134A, submitted all the required financial and biographic documentation to USCIS. USCIS approved the form. And the person from Cuba, Haiti, Nicaragua, or Venezuela also did what they needed to do, provided proof of their identity, entered the United States, Customs and Border Protection let them in. Now they're able to file for work authorization, and they get it, and they're living here and contributing to our community and playing a role and starting to establish their life here. But what next? Right now, there's not a clear answer for that. And if there were to be a clear answer for that, that would be a good time for a follow-up presentation about what the next steps are. But for now, in response to a crisis, the United States has provided a program for people from these 4 countries specifically to avail themselves. The United States has pledged to process a certain number of these, 30,000 of these per month. And once they get here, they're here. At least for the moment, they're safe. But that is an expiring status, and there isn't a long-term plan, and they should expect to depart the United States when that authorized stay expires, unless, of course, some change in circumstances has led to them being able to avail themselves to a different existing program, and they get approval of that, or the United States takes the next step and creates a specific program to allow adjustment of status or some other extended stay for people who have entered with humanitarian parole. While this process has been around for a long time, this particular program for applicants for these 4 countries is something new, and the manner of processing these applications is something new. So I don't know if I'm going to have all the answers. Thankfully, Zur is here, and I know there's some other practitioners online here, so hopefully we can have a good discussion about this. But if we don't answer all your questions today, or more likely, as I mentioned earlier, if you have a specific situation and you want to know about options moving forward for either yourself or the person that you're thinking of, our contact information is here, and you're certainly welcome to call us to see if a follow-up consultation would be appropriate.
And so one of the first questions we have right here is from Gustavo, and he asked, the requirements for the supporters, is it only money in terms of cash or financial, or would it be appropriate, okay, for them to also put down, I'm assuming, real estate properties to demonstrate that they have the financial means to be a financial sponsor?
That's a very good question. And if I recall correctly from a similar program that I provided some assistance with for Uniting for Ukraine, I believe that there is a way for you to submit other assets, like real estate or other financial holdings. It's not just strictly a lump sum in your bank account or something like that. But as the slide indicated earlier, you are going to have to provide documentary evidence of those holdings. You're going to have to show that you actually own these things, whether it's real estate or stocks or some kind of other financial benefit or holding. You're going to have to provide documentation that you own it, and what the amount is, what its value is, and that it's sufficient to meet the standards.
And I would just also chime in too with respect to other properties. Generally, what they will be looking at is if you have other properties like real estate or a vehicle or vehicles, they're going to be looking at whether you would be able to liquidate that particular real estate or property to turn into essentially cash that could be put into a bank account if you needed to. So that would be how you should review and look at your assets, is whether it's an asset that you could liquidate that could potentially be turned into financial cash availability to help sponsor or support the beneficiary that you're intending, or multiple beneficiaries that you are signing up for to help potentially be the sponsor. So that's just a tip. And another tip with that too is generally USCIS is going to be looking at your financial income and assets for your family size in the United States to make sure that you are at or above 100% of the federal poverty level in order to deem that you can qualify to be a financial sponsor for this particular program. So just keep those in mind, okay? Another question is, if the supporter is accepted, meaning the financial supporter has submitted the original documentation and the I-34A is approved, and presumably the financial sponsor has been approved, and then the beneficiary has been processed. I think the question here says, what if the financial sponsor later cannot support the applicant or the foreign beneficiary? What are the options for the financial sponsor?
So, as one of the previous slides said, you can sort of swap out a sponsor. Also, I don't know to what extent, if any, USCIS is going to follow up on these. And if they do want to follow up, I don't know what their capabilities to actually do so are. So I do not want to imply that you should kind of shove together a bunch of documents that might get you approved, knowing that you're going to fall out of standards in short order. But if you, for example, are approved as a sponsor and the beneficiary gets their travel document and comes to the United States, and then you suddenly experience a financial crisis and you no longer feel like you qualify, I'm not sure in practice if that's going to have any negative effect, because at the time, go ahead, sir.
Yeah, let me chime in with this. And some of the questions, we've had similar questions about, more than anything, it's maybe this question is about what is the financial and legal liability, right, for the financial sponsor. If once the beneficiary arrives here, and let's say they're able to help them for the first month or two, but they have run out of resources or financial resources, what is their financial liability or legal liability exposure since they've completed this I-30A form, and how would the beneficiary be able to, or the government be able to, sue the financial sponsor to say, nope, this is a contract and agreement you signed that said you were going to sponsor and be financially responsible for the beneficiary. There is good news on that end, is that from our other immigration practitioners and experts, they're saying that unlike other immigration forms that do ask you to sign on and be a financial sponsor, particularly in a family reunification context for adjustment of status, what's different about the I-134A is that there is specific language in there that's different from other financial sponsor requirements, that we believe that the I-134A is not going to be interpreted as a legal liability for the financial sponsor. As Ryan indicated earlier, once an individual arrives here in the United States, there are other resources through our federal government and state programs that can provide other public benefits or other resources for these individuals. When this program was created, the United States government understands that the population that would be serving and entering into the United States lawfully here would need additional support, even though we may have a financial sponsor in the United States to say, yes, they can fill out this form and at least make the initial vouching to say I have the initial financial resources to help this individual. So I think that for individuals who are wanting or interested in being a financial sponsor, yes, you should show a good faith financial income and asset to show that you can sponsor this individual and help them acclimate and integrate, and particularly once they get here, they can apply for work authorization. But what we've heard is that there is no legal contract interpretation for the I-134A, and that there should not be any legal repercussions in terms of liability or exposure for the financial sponsor. Okay. I'm going to move on to the next question here. I think Joe's asking, are there agencies in these countries, for example, in Cuba, Haiti, Nicaragua, Venezuela, that are helping beneficiaries fill out the forms, etc.? And how many people fleeing trouble in their country have email access? Those are excellent questions. And Brian, you want to address that first?
Those are excellent questions, and I think the answer, is probably going to be we don't know. And then there's always the default answer that tends to apply at some level in every legal question. It depends. So the whole idea of humanitarian parole is that beneficiaries, people in these countries, are experiencing some kind of unrest, disruption, disaster, war, catastrophe. So even if there are agencies in those countries, are they functioning? And, in the case of some of these countries, the government is either not on the same page as the US government, maybe not enemies, but certainly not friends, or perhaps the government's just non-functional. So the agencies, when we talk about an agency like USCIS or CBP, we're talking about a federal organization that exists within our laws to do a particular governmental function. And I don't know if that definition is the same in a country like Cuba or in a country like Haiti or Venezuela or Nicaragua for that matter. Do they even have what we consider agencies? And if they do we trust them? Perhaps a better view of your question would be, are there humanitarian organizations or nonprofits that have a branch in these countries? Like, is there a UN agency or a nonprofit that operates overseas that people might be able to avail themselves to? And I think the answer is, again, we don't know. Or if we do know, it depends. Is the UN present in Haiti right now? They probably are. Does that mean someone would be able to go there and say, I have a friend in the United States who may want to fill out an I-134A for me. Can you help me get internet access so that I can communicate with them and watch my email for USCIS? Again, we don't know, or it depends. It depends on a lot of circumstances. And as to the component of your question of how much internet access do they have, in my experience as a practitioner, most people, even when fleeing terrible conditions, oftentimes do have access to a phone, at least, to allow them to do something like check email. But I would acknowledge that as a barrier. That's a significant barrier. And as I said earlier in our slide presentation, when we talked about the criteria for beneficiaries, it's not without barriers. What if they've lost their passport? What if they just can't get a passport? What if they don't have any proof of their biographical facts? Not without barriers, but it is the program that we have. So again, in terms of other agencies that can offer additional assistance, either we don't know, or if we do know, it depends on whether they're accessible, but we do the best we can with the program that the US government's made available to us.
Great. I'm moving on to the next question here. A question is posed saying, do we know how long this process is taking for Venezuelans? And maybe for that matter, the other countries too. Ryan, do you have an idea?
That is another legal question to which the answer is, it depends. As I mentioned earlier in this presentation, just before starting this presentation and previous to this as well, Zur and I were talking about that, about, okay, so there's supposed to be 30,000 applications that are getting processed a month. Has that actually been happening? And when that is happening, how long have those applications been pending? And when they've been pending for a longer period of time than we think perhaps is appropriate, do we have a reason for that? Is that because there's a backlog, or is that because a certain amount of applications are being submitted without appropriate evidence, so they're taking longer with RFEs? I don't think we have that data back yet. I don't think we know. I think Zur might be able to talk a little bit more about some preliminary statistics or not. I don't know if those if those statistics have been provided to us in a way that we can really rely on them. So
Sure. I can talk a little bit about processing times from the point of someone submitting the form online to the beneficiary, getting the thumbs up and saying, okay, you've been accepted. Now you've been granted or issued this travel authorization document to enter the United States. We have actually observed a pretty wide range of processing times, from a matter of a few weeks to months and months. And so with anything with regards to USCIS and immigration, there is really not a whole lot of consistency. The backlog, or if it's processed quickly, is going to be dependent on several factors. Many times what we're seeing is there are people who we've served already that have already arrived here from those countries, and they were able to get their travel document authorization within a matter of a few weeks. But I also know that the problem in itself, in terms of the nature of this program, that's completely reliant on using digital technology. I know that there's an app that's required for the beneficiary to create an account and access and to check on the case status, called CBP1. That app on a smartphone or computer has been problematic, and the US government is trying to improve that process. So there are multiple delays or issues that may be causing some of the delays. But I would say it may range between a few weeks to months in order for someone to be processed and actually receive authorization to travel and leave their country of origin. Okay. The next question here is, please talk about what happens to beneficiaries if the parolee that they are supporting does not depart at the end of the program time and goes into hiding without the beneficiary's knowledge. I think maybe what the person is asking is the sponsor's knowledge, right?
Sponsor's knowledge.
Yep, what if the parolee beneficiary immigrant time ends and expires, and the foreign beneficiary parolee goes into hiding without the sponsor's knowledge? This question has been brought up by a few conversations with a couple different groups. And so that's a good question, and it's a realistic question. Ryan, do you want to address that?
Sure. So I just want to make sure that we all have the correct terms here. So we've got a sponsor who's in the United States who meets the criteria that we talked about earlier for a sponsor. And then the beneficiary is the person from Cuba, Haiti, Nicaragua, or Venezuela who benefits from that, comes to the United States after being vetted and approved by USCIS and CBP. And the question here is, the sponsor fills out the paperwork appropriately, and the beneficiary complies with the process appropriately, comes to the United States, and then their authorized stay expires. And instead of choosing to go or leave the United States, I should say, we don't expect them to necessarily go back to their own country, but they, instead of departing the United States when their stay expires, they just choose to disappear and become part of the undocumented population. So what if that happens? What if indeed? So let's talk about what if for the sponsor. If you in good faith have sponsored someone and you believe that they in good faith are going to benefit from this program appropriately, and then that person chooses not to do that, it's kind of similar to the financial obligations. So far as I know, there is no legal consequence that would come back on the sponsor because they've done everything correctly that they are supposed to do. when you're the sponsor, it doesn't mean that the beneficiary, once arrived here, is like your job to police and to control. No, you've fulfilled your role as sponsor. And if the person chooses not to follow US law, then that's on them. I mean, perhaps a similar facet of this would be, what if you're the sponsor and someone comes here appropriately through the process as prescribed, and then they get an OWI, they get a drunk driving charge, and now they're in jail. You know, are you required to do this, or are you required to do that? No, that's on the beneficiary, that they should follow US laws and policies and do things correctly. So as far as I know, if you've done everything in good faith as a sponsor, there would be no consequence for you for that, nor should there be. I think that's an appropriate status of the law. For the beneficiary, if they choose to overstay, once their authorized stay expires, they will lose access to the benefits that were listed on that slide previously. And they will, once outside of status, no longer to be able to work with authorization. And the level of stability and comfort that they've enjoyed in the United States will now, of course, change, because they have lost access to certain kinds of support because they've chosen to go outside the prescribed immigration benefit and laws that apply to them. What specific immigration consequences can attach to that, and the specific circumstances of a given beneficiary's life that led to that choice, are something that I would recommend for probably a specific legal consultation. I mean, if someone is just, you know, choosing to game our system, of course, that will eventually catch up with them, and there will be serious legal ramifications for that. If perhaps the circumstances of their life have changed and they're eligible to adjust their status or apply for a different program, and they're just running out of time and they don't have a plan to depart, or that deadline has even passed, but they want in good faith to access, you know, whatever options are available for them, you know, there we start to get into a myriad of different circumstances, laws that might apply, and you know, actions that we might prescribe. And that would be something in those circumstances that, you know, someone who, again, in good faith wants to remain within our laws should really come to a legal provider for a consultation to see what their options are. And, you know, if they don't want to go and find out what their legal options are, they just don't care and want to go into the undocumented population and wing it, that's a very serious legal choice that will probably have consequences that catch up with them later.
Well, right, we have, I think, maybe time for one more question. I think this is the last question I'm seeing in the chat too, but what would happen if the parolees have Nicaraguan citizenship rescinded by their government? And maybe I can take a stab at that first.
Yeah.
And this is a specific question for Nicaraguan nationals. What I'm aware of is, recall Rye talking about what the beneficiary is required to do on their end. They actually have to possess and have a valid passport from the country of origin, with the slight exception for Nicaragua, because of the particular situation in Nicaragua, in which the government in Nicaragua said that if any Nicaraguans leave the country, they are going to strip them of revoke their citizenship, and also potentially some of them are not able to renew their passports in Nicaragua. My understanding is that there is exception that I believe also for Nicaraguan and Venezuelans, that those two countries, nationals for those countries, there may be exceptions that if, let's say, their passport has expired, I believe for Venezuelans that if their passport has expired, that they still should be able to be eligible to travel with the expired passport. Nicaragua, we need to double check, but I think that there may be some updates with that too. And of course, just like with anything with immigration these days, the law and requirements do change rapidly and quickly. But if you have an individual that is in that particular situation, I would highly advise that the petitioner, or in this case, the financial sponsor, schedule a legal consultation with one of our attorneys so we can ask additional clarifying questions to make sure that we have all the information that we need in order to give you the best legal advice to share with the beneficiary in that country of origin. So those are also great questions. And I think because it is 12:59, if you have further questions, our contact information is on this last slide here. Feel free to email Rye or myself or call our office at the numbers listed, and we will be in touch with respect to any questions you may have. But at the end of the day, we appreciate you joining us today. It's really important that if people have legal questions, that they actually meet with and talk to a qualified legal services provider. We have seen clients who've been unfortunately deceived into losing out on thousands of dollars by going to an unqualified non-attorney to complete immigration applications and forms and to get legal advice. So again, that's just another reminder for you all to share with the community. Thank you for joining us this afternoon, and thank you to Rye for providing such excellent information for our audience. And thank you to the audience for joining us for this afternoon hour to learn a little bit more about the humanitarian program.